Hi, everyone. Welcome back to the Teach Middle East podcast. My name is Lisa Grace Wilson, as you know by now. And today, I have a treat for you. I've managed to bag a lawyer. No, not that way. I'm already married. Get your minds out of the gutter. I mean, bag a lawyer to help us with all our labor law issues here in the United Arab Emirates. So I'm honored today to have with me Ahmad AlKhalil. And Ahmad is a lawyer based in Dubai, and he's offered us his time, free, people. So you really have to look out for him when you see him on the streets and tell him thank you from the Teach Middle East family.
You are listening to the Teach Middle East podcast, connecting, developing, and empowering educators.
Welcome, Ahmed. How are you?
Hi, Lisa. Thank you for having me on. It's a pleasure to actually be here. You know, some of us I pride myself on being a lawyer with a part-time conscience. So I do give free time every once in a while, but happy to help out when it comes to teachers. It's a very important, noble profession, which I don't think is appreciated enough. So happy to give back when we can.
Thank you. We really appreciate it because today's podcast is about the UAE labor laws. Teachers, know your rights. And so after everything that's happened over the last 2 years, we're really, really happy to get into some of these topics. But before we get into the topics, I'd like you to do like a little intro so that we know who we're talking to.
Yeah. So hi, everyone. My name is Ahmad AlKhalil. I'm a partner and head of the corporate department at Hamdan Al-Shamsi law firm. So as Lisa said, we're based out of Dubai, and we are a local firm who represent the clients at the courts. So we're mainly a litigation firm. We handle all sorts of matters, employment being quite a big subject at the moment because of certain changes. And, you know, if you're not employed, you're employing people, and there's always some dispute occurring. So yeah, I think that's pretty much all they need to know right now. It's self-explanatory, lawyer.
Yes. And so we are going to just make it so that we put this podcast in scenarios because we might find ourselves from one time or the other in different situations here in the UAE. And we might need the advice of a lawyer. But before we go into getting advice, we need to be knowledgeable about what's going on. So let's just take it that you've just flown into this country. You signed loads of papers. Some of them you didn't read. Let's just be honest here. We didn't read them all. The fine prints are a lot. But you do get an employment contract. And I thought you could get one or the other. You could either get an unlimited contract or a fixed term contract. What's the difference? What's going on with contracts? What types should we expect?
Yeah, so based on the old law, you could have an unlimited and unlimited term contract. Now, from February 2022, they introduced a new law and only made it into a fixed term contract. So back in the day, the reason being that unlimited ones were used for purposes of longevity. You know, somebody is coming into the country, is going to be here for a long time. Instead of having to renew it year on year, they just opened up to unlimited term contracts. There was a difference between being unlimited and an unlimited. Right now, all of them are being standardized. And by February next year, 2023, everyone is going to be on a fixed term contract. So there will be no changes or no differences between everybody's contract. It is a standard template for all. So they're trying to make it so that your visa, which is an immigration matter, and your contract align at the same time. So that if somebody needs to leave, they're leaving within the period of the contract or their visa expiring.
So are contracts then going to be 3 years like your visa?
They should be. They should be. Now, of course, I say should be because we've hit a hiccup already with the relevant ministry here in the UAE, which is called Ministry of Human Resources and Emiratization. Ministry of Labor, let's call it. The law says that you're allowed up to 3 years fixed term contract. When we applied for 3 years, they said, no, we are only allowing 2 years. So to add the complication. So they might change that. And this is something that everybody has to understand is that sometimes the letter of the law is different than what is practiced in the market. And this is a perfect example. They're saying 2 years maximum. Visas will vary between 1 year, 2 years, and 3 years. Some of them go up to 10, depending on the type of visa. But everybody is going to be on a fixed term. And so far, it looks like it's going to be 2 years as a maximum cap.
Right. And so that then becomes renewable with the employee and the employer's consent, right?
Yeah. So either of two scenarios. If neither party discusses the employment contract, it auto-renews for a similar period of time. If there are, let's say, discrepancies, or if there is a dispute between the employer and the employee, I want a raise, the employer is saying, I don't want to give you a raise, then it will terminate because of the end of its term. And they have to renegotiate a new one. So it really depends on the situation. If there's amicable mutual agreement, it automatically renews on the same terms. If there is no amicable settlement between the parties, or there is some form of dispute, it terminates and the negotiation for a new one then kicks in.
So what happens in this time when the law is changing? What happens in this limbo time? Which one takes precedence?
You mean if there was a dispute?
Yes.
End of contract until further notice. So it's same as a rental contract. It comes up, let's say, in February of 2023, March 2023, there has been no discussion. I mean, you have not reached an agreement. You're terminated. The lease contract is terminated. So you have to leave the premises. It's the same with the employment based on these new contracts. The old law was slightly different. I don't know the reasoning behind it, to be honest, why they tried to make it fixed term. It genuinely doesn't give any advantage or disadvantage based on the new law.
So you know how now things are going the way of fixed terms for employment contracts, but at the same time, they're rolling out things like a 5-year green visa for professionals, which teachers fall right in that category. How do those two work together? Do you have any idea?
So one thing that people have to differentiate between two items. Your employment is separate to immigration status. So the visa and the employment contract come hand in hand, but they're not tied into each other. So you can still have a visa within the country, basically the green visa or the golden visa, or even sometimes working off of your husband's visa. It does not preclude you from having employment contracts with several individual companies during that period of time. So a lot of times we're asked about, well, my visa has run out, but I'm still technically employed by the company. So you being employed is a matter between you and the company. The immigration status part has to do with the immigration department, which your employer, if you are on their sponsorship, will be paying fines on as the employer, not you as an individual. So you have scenarios where sometimes the employment contract is still running, but the visa has expired, or sometimes the employment contract has expired, but the visa is still running. Two separate matters that come in hand, but one doesn't negate the other.
Oh, that makes sense. So you can still have a visa going, but your employment contract could have been terminated. I get that. So that's how that green visa thing will work. But let's talk about something that's on pretty much every new teacher's mind and every teacher that's been here for a while. How is the gratuity calculated after you finish your probation period? Because most schools, they'll give you like a 6 months probation. And then after that, you carry on for the rest of the academic year for the term of your contract. But then at the end, if you want to leave, what should you expect as a gratuity in terms of calculation?
So with end of service benefits or gratuity terms being interchangeable, the main important point to remember is that it is a 1-year cutoff. Anything prior to 1 year on the contract, you will not earn any gratuity or end of service benefit. None.
Sorry, Ahmad, stick a pin. One calendar year or one academic year?
No, 1 calendar year, 365 days.
So that's touchy for us.
Yeah, because I understand that with the contracts for teachers, they normally do the academic year, but the law is defining it as a full calendar year. So you have to cross 365 days. From that point onwards, you will start accruing end of service benefits and gratuity. Prior to that, you will not earn any of it, unfortunately. The probation period is 6 months. That's usually common practice for most employers in the country, be it schools, law firms, banks. Normally, they give that 6 months probation period. Now, let's say you go into and you work for 4 years with the school. End of service gratuity is calculated on your basic wage. So in the UAE, they have the basic wage and you have full wage, which includes allowances. So more often than not, you'd see 60% being the basic wage. Let's say it's 6,000 dirhams. allowances of another extra 4,000 dirhams, housing, utilities, so on and so forth. When you calculate your end of service gratuity, you're only taking into account the basic wage. So we're looking at 6,000 dirhams.
Mm.
For the first 5 years of your employment, you take 21 days of every month per year. That's the calculation. So 6,000 is not actually granted as 6,000. It's 6,000 dirhams times 21 days divided by 30. That'll give you a value. That value is per year of service. So if you've been there for 4 years, it's that amount times 4. You get for the 4 years. If you've worked, let's say 7 years, for the first 5 years, it's the same calculation, 21 days of the basic wage. For years 6 and 7, you earn 30 days. So it's the full 6,000 dirhams. So it's slightly different between the two of them.
Right. So you must work 5 years first before you can get that full 30 days basic wage calculation per year.
Yes, per year.
And
it's prorated on the number of months. Let's say you worked 5 years and 6 months. It's prorated for the 6 months based on the full 30 days after the first 5 years. That's the problem. It's on basic wage.
Yes. And I didn't actually realize that it wasn't on your full package. Is there anything that makes it mandatory for the employer to make 60% basic and 40%? No. So an employer could make 40% basic and 60% allowance to reduce their bill.
Oh, yeah, of course. And we've seen it. If you take, for example, real estate brokers or agents, their salaries, their basic salary on the contract is around 1,000 dirhams. That's it. Everything else they are earning as commission. So 1 month they might earn 1,000 dirhams. The next month they might earn 500,000. And end of service will be based on that 1,000 dirhams. That's it. And that's the problem. So there is no regulation on 60-40 being basic versus full wage or allowances, but market practice has been 60-40 usually. So our advice is always tell them, I want the higher percentage for the basic than the allowances, because at the end of the day, you're going to get a full salary anyway. From a teacher's perspective, you should try to get the higher basic rather than the higher allowance, always.
Is that negotiable any at all?
It really depends on the school. I mean, or the employer as such. I mean, the school my kids go to, the teachers are treated top notch, genuinely. And this is the feedback we get from the teachers themselves. They pay them well, they treat them well, and they do go for the 60-40. However, we have also seen the other side of some certain schools where they go absolutely the opposite direction. They're paying them 2,000, 3,000 dirhams as basic salary. And then the allowances are, let's say, another 10,000 on top because they want to mitigate the risk at the end of their employment and not pay them as much.
Right.
And now, because this is a new law, the law should always be seen as the bones, and the meat and the skin are the Court of Cassation decisions. So the Court of Cassation will come in and say, it is now mandatory to do it 60-40. They might come in and say that. It's not in the law, but it becomes kind of like precedent for instructions as to clarify the law. Previously, they didn't define it. It was never there. So I don't know if they will do it. We haven't seen too many cases reach Court of Cassation just yet. So, I mean, I guess watch this space. Maybe it will be defined later on. But as of yet, we don't have that clarity yet.
Yeah. Do employers are they mandated to give you a copy of your employment contract? Because I'm now sitting here thinking, have I seen all of my employment contracts previously? Because I've been here for 12 years and I've seen the law change quite a bit since I've been here. And now I'm trying to, in retrospect, think whether or not I've been given all of those. I can't remember. But is there anything in law that says I should have been?
So yeah, the law does require that both parties have copies. Again, in market practice, we've seen it where they haven't handed it over. However, if you do go to the relevant ministry, so it's again the Ministry of Labor or MOHRE, let's call it the abbreviated version, you can request a copy of your employment contract. They will ask you for either your visa residency page or your Emirates ID, and they will issue a new copy or give you a certified true copy of the original. So even if you don't have it from the employee, you can get it from the ministry. The complication happens sometimes. So it used to be market practice for you to have two employment contracts. You have the official ministry version, and sometimes you used to have one that is internal between the employer and the employee. Sometimes. I don't know if schools, it's common for them, but in other sectors, it is very common. And usually they should mimic each other. They usually do, except the ministry one wasn't too meaty. So you'd have very basic information. The new templates that are issued by the ministry are all encompassing. You don't need more than just that document. The reason I talk about this other document is sometimes we've seen that the employer has not given them a copy of that document. That one is never registered. So we always say, take a copy. If they're refusing to give you a copy, make a stir out of it. You have to. This is your right to have a copy of a contract you've signed. If they don't give it to you, you can extract it from the ministry directly.
Right. So leading on from that, in your contract or all contracts, if you're being brought in from overseas or maybe hired locally, what is the difference? Because sometimes you see a contract and it will say local hire and another one will be overseas hire. What's the difference between the two?
To be honest with you, there really isn't a difference. I think most people used to do it that way to avoid the flights or the tickets for returning home. So a lot of ones that are hired locally might not ask for an annual ticket back home or where is home. But in terms of definition, there is absolutely no differentiation from a legal perspective. Now, some employers will come back and say, oh, well, you're not leaving the country. I don't have to pay you the repatriation ticket. By law, they have to pay that repatriation ticket, even if it's not listed in your contract. Now, the one scenario happens is, let's say, I'll give you two scenarios. So the teacher, for example, decides that I no longer want to work with this school. I want to move to a new school. That ticket, the repatriation ticket, does not get paid by the existing school because she is staying within the country. The burden becomes then on the new employer to pay it if she decides to leave the country. So a lot of people, what they do is if they've resigned, they leave at the end of the school year and they say, you know what, I want to go home and enjoy 3 months of not doing anything. I don't feel like working or being in the UAE. They can take that repatriation ticket, go home, and then come back at their own expense or the expense of a new employer. But if they transfer their visa from the existing to a new one, the existing one has a right to say, I'm not going to pay the repatriation. That has moved on to the new employer. But there will be one eventually that takes that individual back home. It's a one-way ticket. Yeah.
Yeah. Good lead into this thing. What are the mandatory benefits that you should expect as an employee in any school, apart from your basic salary?
Yeah. So I guess the important ones are, for example, annual leave. It's important for people to know. One thing I have to say about the law is it is the bare minimum that can be agreed upon. If an employer decides to give you less than what is written in the law, it automatically goes up to the minimum of the law. For example, if I have contracted with the school to say that I will get 20 days of annual leave, the law will grant me 30 days, which is the bare minimum that you should expect. Even though I've signed on it, you will be granted 30 days. So that's something that they should know. 30 days annual leave is the bare minimum that any person should expect. You also have items like 1 day minimum requirement for a rest day. Now with schools, you will be granted to, I've seen some schools where they ask the teachers to come in on one of the days of the weekend. They have a right to. Again, that's a negotiable part, but 1 day a week is mandatory rest day. If they ask you to come in on one Friday, then the second Friday, they have to give you 2 Fridays in its stead. They add on to your annual leave. And they cannot ask you to work more than 2 times. That 1 month, that you're not allowed to work 2 times over the weekend for that rest day. You have other items which are, for example, during Ramadan, hours are reduced. That's by law from the government. You're issued a circular saying times are less. The overtime, it's a bit of a difficult position because the law does say that you are owed overtime. But in order to show that you've spent overtime, you have to have been instructed to stay in the premises and do work extra above and beyond what you were contracted to do. Now, the law says 48 hours per week per person. That's the maximum, supposedly. unless you're in a position of management or you have a position which demands that you spend more time. And that's the problem. Every position demands that you sometimes have to spend that time, but doesn't mean that it's necessarily going to be paid out. So what we've told our clients is, and teachers can say the same thing, is send us an instruction for us to be staying overtime so that we have to complete the work. Again, it's a sensitive topic that the management probably will not allow it, but it's worth documenting it some way. Other things that you need to understand are, you have things like maternity leave and paternity leave. Paternity has been granted recently and it's 5 days. It doesn't actually say how many years you need to do it, but you have 5 days. It's 60 days for maternity plus ancillary days in certain circumstances. What are the things? You have compassionate leave. There are a lot of these things, but the bare minimum, I would suggest when you look at that template contract, that you cannot amend. So whatever's written into that contract stays. So the added advantage of what they've done recently with that template is you can't amend it. So other than putting in a salary, the name and the details of the individual, and maybe the notice period and the probation. That's it. Everything else is as per law. So it gave comfort to people who are signing them, not knowing what their rights are. Because now I know this is the bare minimum. We don't need more than this. I've said it before. If you Google a term that you're not happy about or you'd like to know about it, more often than not, you're going to find an article by a law firm talking about that specific topic. I would just always tell them, make sure that it's talking about the new law rather than the old law.
Right. And remind us again, Ahmed, the new law starts?
It started already, February of 2022. Yeah.
Right. And it's rolling out. And by March of 2023, it's fully in place.
Yeah, it is already in place, but they've given a grace period to employers to say that if you are on the old contracts, the unlimited term contracts, you have 1 year to adjust the position of the employees. So it is already automatically applying. I mean, we got asked the question, what happens if right now I'm on an unlimited term contract and the new law kicked in? And let's say I've been made redundant or they've terminated my services. What happens then? Do they apply the old or the new? The answer is they will automatically apply the new, even though you had a contract back then. So automatically the new provisions kick into place, which I've said it before that it's not to the benefit of the employee, unfortunately. It's more geared towards the employer.
Right. All right, let's get to the meat then. Do schools as employers or school groups, etc., do they have to provide accommodation or an allowance?
The law says that there is no bare minimum other than to say there is a salary. Whether it's that you call it allowance, you call it utilization, you call it a basic wage, you call it full wage. The law doesn't get into that, but it does differentiate between basic wage and full wage. Full wage being all accommodation and everything. The employer has a right to either give you an amount, provide you with the housing as per their requirements and as per the buildings they are contracted with, or they have a choice of saying, I'm not going to give you housing, but your salary is higher. So having that minimum saying that we will provide you with housing is not a requirement. It depends on the salary you're being granted. So if you're being granted, let's say 25,000 dirhams and no housing, is the same as saying 20,000 dirhams basic and 5,000 dirhams housing. So they don't really oblige the employer to put in that number. Some people don't even have, it's just one number. It says basic wage, 25,000 dirhams, and that's it. They don't get into more than that.
Wow. Okay. Interesting. Let's say I'm here. I'm not so happy. Not everybody finds joy when they arrive. And it's September. For some teachers, the reality of the situation is just starting to sink in. Yeah. And they might not be liking it and they want to leave. What kind of notice period does the law require?
So the law talks about a minimum of 30 days and a maximum of 90 days. Usually the default is 30 days. That's what we've seen. If neither party requires more than 30 days, it's automatically put in as 30 days. If it's not stated, then it goes to 30 days as well. With teachers, I've seen a few of these contracts and some of them have had 3 months notice periods. because they need to close out the year or to start preparing for it. If it's 90 days, then you have to serve the 90 days, but you will get paid for the 90 days. If it's 30 days, then you can get paid for the 30 days. That's your notice period. The one exception that I have to mention here is during probation period. So this is something that we've been asked about. The old law used to say during probation period, you can terminate an individual immediately on the spot that day, and they're paid up to that day. That's it. Under the new law, if you are terminated, then the employer has to give you 14 days notice. And you get paid for 14 days, so you have time to adjust and to do what you do. It's not a long period, unfortunately, 14 days, but it's something. On the other hand, if the employee resigns, you've got 2 time limits. If they resign and they're leaving the country, they have to give 14 days. If they resign and they're staying in the country, it's 30 days notice during the probation period. Usually the contracts will have all of these terms. So with these contracts, you will see most of this information provided already. The old ones were horrible. The new ones have all the information you need.
Mm-hmm.
So notice depends on the mutual agreements between the parties.
Right. We get asked this a lot. If I resign before my fixed term contract, say, for example, 2 years, or let's say I resign before I finish even 1 year, does the employer have the right to recoup any kind of money from me? Let's say money back for my ticket or money back for my accommodation or money. What can they recoup from me as an individual, or even the cost of my visa?
Yeah. So again, I referred to the old law and the new law because the new law clarified a few things. So back in the day, the old law, if you were terminated or resigned, it's just tough luck for the employer. They cannot recuperate any recruitment costs. They're calling it recruitment costs now. Under the new law, the old employer has a right to recuperate costs, recruitment costs from the new employer, not the employee, from the new employer. So the employee at that point, but they say that, but it's indirectly going to affect the employee because the new employer is going to say, well, why am I paying it? You need to pay it as an employee to me for me to pay it back. But they gave them the option of recuperating those costs. Now, what is considered recruitment costs? It's at least a visa cost, we believe, possibly insurance, and maybe if you've paid for a ticket. We still don't know. Again, this is where the Court of Cassation will come in. We believe the minimum is going to be the visa, but it's not out of the pocket of the employee. It's out of the pocket of the new employer if you stay within the country.
But if you leave, though?
If you leave, nobody gets paid anything back.
No, but what will happen is, or what might happen is that the school or the school group may say to you, in order for us to cancel your visa and for you to leave the country, you have broken the contract. They're going to give you a sum of money. You must settle this amount of money before you are free to go. What happens then?
So the law is very specific on what sort of deductions you can take out of an employee's salary or the end of service. That's a loan. So if you've taken out a loan from the company, fair dues, you have to pay it back. That gets deducted from your end of service. There are certain provisions, the main one being that loan deduction. Recruitment costs is not one of them. Even if it's written into the contract, they cannot ask you to pay it back, ever. So we've seen it where they've held people to ransom saying that we're not going to pay you anything unless we deduct this amount from your end of service. At that point, I would tell you, you need to file a grievance and go down the route of the courts, or at least the initial part of it, because they're not permitted to do that. And then the courts will tell them and instruct them, you need to pay the full amount back to the employee, unless it's one of those exceptions, like taking a loan. But otherwise, they're not allowed to ever ask for those deductions. To a point you mentioned before, sorry, I forgot to talk about it, is what happens if you break a limited term contract? The old law used to say there is compensation by either party if you break a fixed term contract. The new law doesn't. So if you break a fixed term contract, that's it. You pay notice period, you pay end of service, and annual leave that's accrued but hasn't been used. That's all you're going to pay. Back in the day, it used to be that you have to compensate the employer if you resigned, or you pay the employee if you have broken the contract before time. Again, this goes back to me saying that it's not always to the benefit of the employee, the new version of the law. But this is the way it's been drafted, and we're going to have to live with it now.
I get it. I'm just kind of putting myself in at the teacher's position and just thinking about what are some of the things that would bother them. A lot of schools ask you to give your intention for the next academic year early. And when I say early, I mean October, November. Sometimes you have to, I promise, you have to sign to say you're thinking of renewing for the next academic year. But let's say you've done your contract or you've done a full year of your contract, and at the end of the maybe term 3, which is round about June, thereabouts, going into July, you decide, hey, I'm not coming back. Can the employer hold you essentially a ransom to say you didn't give your intention, you can't go? What rights do I have? Is it that I can just give them 30 days and walk away?
Pretty much. I mean, here's the thing. If they don't like what you're saying to them, or you don't like what they're saying to you, you just resign. They cannot hold you and say, well, she gave us an intention of staying on. Things change. Circumstances change. You have a binding contract. That is by far and away more powerful than a letter of intention. So if you are leaving the school because you're unhappy, because you haven't been paid, whatever the reason is, you are going to be resigning anyway. So that letter of intention is not worth the paper it's printed on. They kind of do it so that they're getting some comfort. I've understood that they try to do it so that they guide the courts to say, well, she told us she wanted to use it to come back next year. But they cannot force you to come back if you are unhappy. Or let's say, what if they haven't paid you in 3 months? Why would you stick around? And why would the courts hold it against you that, well, you gave them an intention? So no, I think that used to be common practice when it was unlimited term contracts, possibly, to show that, yeah, both parties are happy, we want to do it, but it's not going to be enforceable.
I think it's a thing schools do in order to gauge what they need to do recruitment. But I guess, as you said, they can't really hold you ransom. If you get to April, May, June, and you decide, listen, I want to go, you can just give your month's notice. I think schools do require, lots of schools, and my listeners can tell me this in the comments and in different places. Do schools still ask for a full 3 months, even with this change of law? I think a lot of schools might, or school groups might still ask for that. But what if the shoe is on the other foot and you're being let go? Is there such a thing as redundancy in the UAE?
No. So this, again, goes back to the old law versus the new law. Under unlimited term contracts, if you terminate an employee outside of certain provisions and articles in the law, which are very hard to come by, it's like stuff like found drunk and disorderly, or failure to perform after being served 2 notices. There are a few of them, about 11, I think. You used to get something called arbitrary dismissal compensation. That's up to 3 months of your salary. That has been removed completely. Whether limited or unlimited has been removed. Nowadays, based on the new law, if you are terminated or you resign, you are entitled to your end of service and notice period. That's it. Sometimes, certain circumstances, you can not be granted the notice period. And those are provisions, I think it's Article 44 or 45 of the new law, which says those that are drunken, disorderly, false identity, certain ones. At that point, you still owe the end of service, but you will not give notice. So there is no compensation. The one situation that allows you that compensation is if you filed with the ministry, let's say, they're calling it a serious grievance. I don't know what serious is. If you're filing a grievance, then it's considered serious. But let's say they haven't paid you in a month and you file saying that these guys have not paid me, and they retaliate by firing you, you will get compensation. That's the one exception to the rule. If they retaliate after you've filed the complaint at the ministry or at the courts, and they retaliate by firing you, that you are granted compensation, but we don't know how they're going to calculate the compensation again. So watch the space, because it will come by the end of the year. Maybe 1 or 2 cases will come along. But I think it'll be a maximum, again, similar to the old law, a maximum of 3 months compensation. But genuinely, I don't think they will go that high. It'll maybe be a month of salary, maybe 2.
So you're telling me that if I'm working in a school I feel bullied. There is something tantamount to constructive dismissal. I'm being pushed out. Really, I can only expect to get my 1 month notice period pay, and whatever my end of service is, that's it. I have no recourse to actually take them to court to be compensated for more.
No, unfortunately, that's the. I mean, we say this quite a lot. It's difficult.
I'm giving you the sister girl face right now for those who are listening. I'm giving him the what? You said what?
I don't like being the bearer of bad news, but this is the harsh reality. You know, I mean, what we have to always explain to the clients and to the people we talk to is the law is not necessarily about being fair and unfair or logical or illogical. The law is the way it is, and we have to deal with it. And I've said it before, the law now is not geared towards the employee. It's geared towards the employer mainly. And I don't know why they did it this way or why it's become this way, but it is what it is. Yeah, I know. I promise you when I tell you I feel for the employees more so. It's a difficult situation. It really genuinely is a difficult situation.
Yeah, I think now it's really up to companies to use their conscience and to treat people fairly and to treat them with respect. And here's the other caveat. If you treat people poorly, eventually you will not have the best and brightest and greatest talents working with you, because news travels fast. And as much as you can't slander in the UAE and you can't go out and, shout a company's name from the rooftop, believe me, people know who the bad employers are, and people know why others leave. We just know because we are humans and we know what we do. We know how to make it known. Quick question for you, Ahmad, because you've been so generous with your time and your expertise. I am so, so grateful. You find yourself in a difficult situation here. Where do you go for help? What's your recourse?
So your first port of call would be the ministry itself. So the ministry has a kind of like a reconciliation center or a mediation center where you file this grievance, they call in the employer and they call you in and they try to resolve it amicably. Now, it's an avenue, but it's an avenue that doesn't have teeth. So they can't force one or the other to do something they don't agree to. Once that reconciliation or mediation is done and dusted, they give you a piece of paper. Let's say you didn't settle amicably. They give you a piece of paper so that you go and file a court case. I would always tell people, I know it's counterintuitive, but I would say avoid the courts like the plague, because at that point, it's going to take time. It takes between 6 months and 9 months for the judgment to be issued. It'll cost you time, money, heartache, and pain. But if it genuinely is something that if you were genuinely mistreated and they're not granting you your rights, go for it. Employment cases are by far and away the simplest form of cases. The law is very small, very specific. Our advice is always, you don't have to hire the lawyer for the full term of the case. It's very simple stuff. But that first memo where you're asking for your rights is the most crucial and important document. We can tell you what you need to do. The courts here are not about what you say to them. It's what you present to them in paper. So once you find that claim sheet and it has exactly what you're looking for, that's the most important document. Everything else from that point, I mean, subject to what the counterparty submits, but everything from that point, you can do yourself. It's not as daunting as you think it is. Most of it is online. They call out your name. They ask you, so what's happening now? You're like, I'm submitting my claims document. They will ask the counterparty, would you like a judgment or the chance to respond? They'd say, respond, go away for a week. So it's not as daunting as a lot of people think it is, but it does take time.
6 to 9 months.
Yeah, it's a long time. But something I have to stress here, because we get asked this question and people are terrified of, well, if I have to go to court and I can't cancel my visa in this period because I'm still going through a court case, what happens if I find new employment? Well, the ministry grants you something called a temporary work permit. So you are officially working with the new company. You're not on their visa yet, but you have an official work permit. So you are legally working here with no repercussions against you. Even if the visa expired while the court case is ongoing or the dispute, the penalties that are accumulating are on the school, not on the employee. So you shouldn't worry. A lot of people come to us thinking that because they are going through a court case and their visa is still on the old employer, that they cannot be employed by somebody new. And we have to make sure that we explain to them that there is a procedure. Just ask about a temporary work permit. You'll be right as rain and you're working legally and you are pursuing the court case so that you get your rights.
Right. Amazing. If you need a lawyer, though, gosh.
Yeah.
How does a lawyer typically charge? I mean, how do they charge?
So it depends. Some firms will charge you on that initial consultation. Some firms charge you a fixed fee or an hourly rate. Fixed fee is always the best option for the teacher because they know right off the bat how much it's going to cost. It does go up higher if you're going on an hourly basis. Now, some firms like ours, we don't charge for the initial consultation. We feel as though this is our corporate social responsibility. We sit with the people, we explain to them what we do and how we can help. Maybe 6 out of 10 times, they can go and do it on their own. Or they engage us for just drafting that initial memo. That's it. The rest, we will explain to them what they need to do and what to anticipate. Because at the end of the day, if somebody is earning 15,000 dirhams, they're not going to pay a law firm 35,000 dirhams to file a case. It doesn't make sense. And it does, because when you think about it, it's going to be a case that's dragging on for 9 months. And in the 9 months, that's potentially 9 sessions, court sessions. So it is an expensive endeavor. And that's why I say with employment, have that initial consultation, find a firm that might not charge you for that initial consultation. They will give you the direction you need to go. After that, just get them to draft the initial memo. From that point onwards, you can do it on your own. Because the courts, like I said, it's not as daunting as you think it is. It's a waste of time sometimes, but you still can do it on your own.
Yeah.
They could easily resolve it in 3 months. I don't know why it takes 9 months, but it is what it is.
Yeah. Wow. So much info and so much goodness and so much richness. I am so grateful to you, Ahmad, for the time. Teachers, if you want to reach out to Ahmad, what's the best way they could reach out to you should they need your services?
Either they can contact the firm directly. Lisa, you have my details. Please share it with whoever would like to, either by phone, email, any means, carrier pigeon if they prefer it. The address is there. So
no
any
problem.
way they would like to, we're happy to help any way we can. And like I said, for those initial consultations, we don't normally charge. We don't like charging because we don't know how much we can help. So do find the firms that will be able to provide you with that service to at least guide you in the right direction.
Amazing. I'm going to put your contact details in the show notes of this podcast. If people have really tough, cases that they're facing and they want to get in touch, please do click the links, connect with Ahmad, and obviously do your research, do your reading, the law. Is there any place online where we can find this information, just the law itself so we can read all the clauses?
Yeah, so the law itself is actually on the Ministry of Human Resources and Amortization website. So if you type in UAE labor law, look for the one that says mohre.gov.ae. That one has the law and even has a calculator for your end of service. So it can do the calculation for you. But like you said, it's important to research. I mean, if you just type in the question you're looking for on Google, 9 times out of 10, you're going to get a response there. I would always look at the ones that are published, not in Khalij Times or one of the newspapers. Look for the ones that are published by lawyers. They're the ones you should use. Because we've had certain circumstances where information was provided and we look at it, we're like, this is not what the law says. Yeah. So follow the ones that are issued by law firms. Most of the information is out there. And like I said, because it's a simpler law, 9 times out of 10, you will get the information you need from there. If not, speak to someone, speak to a lawyer, somebody that you believe, and ask about them as well. Word of mouth. Do you think these people are good? Most people in the UAE at some point have, as morbid as it sounds, have needed a lawyer at some point or another. So sure as hell, somebody is going to be able to give you that information about somebody they trust, they've used, and that can give you and guide you in the right direction.
Fantastic. Thank you. Thank you so much for being on the podcast with me.
Oh, yeah. Thank you so much for having me, Elisa. And please do reach out if there are any other questions. If somebody has specific ones, happy to help any way we can.
Brilliant.
Thank you for listening to the Teach Middle East podcast. Visit our website, teachmiddleeast.com, and follow us on social media. The links are in the show notes.